Hi, I'm Laura Barker and I'm an Ombudsman at the Legal Ombudsman. The Legal Ombudsman investigates complaints that are raised about legal service providers such as solicitors or barristers. We're an independent and impartial organisation, so we fairly and impartially investigate complaints by speaking to parties to establish exactly what the complaint is and by obtaining evidence to reach a decision on whether we think the service was reasonable or not. Today I'm going to be talking to you about family law. Family law is one of the top areas of law that we see complaints being made about. For example, between 2017 and 2018, we had around 13% of all of our complaints were in respect of family law cases. That's stayed consistent probably over the last 5 or 6 years or so. And to put that into context, it means that last year we saw about 770 cases that related to family law complaints. Family law complaints include complaints about divorce matters, the finances arising out of a separation, and children law matters. And actually, sometimes we see individuals who've instructed a lawyer in respect of all three at the same time. In respect of family law complaints, the most common types that we see are in respect of a failure to advise and failure to follow instructions, also in respect of delay, and then finally in respect of costs. So when it comes to a failure to advise or a failure to follow instructions, what we tend to see is this stems from some poor communication. So perhaps the individual isn't sure of what's happening in their case, they don't know what the next steps are, or they don't understand the process that they've fallen into, and as such they believe that there's been a lack of advice from the solicitor, or that the solicitor's not taking on board what they're telling them that they want to do. In respect of delay, again, this can often stem from communication issues as well, because whilst a legal service provider may well be actively working on a case, if they're not updating their client, then they perceive that as being delay or lack of progress or lack of action on their case. Finally, in respect of costs, we see complaints about costs being excessive, but also a lack of cost information. These are often linked because if somebody receives an estimate at the start, their costs end up being much higher. It's likely because they're likely to be upset because they haven't received updates throughout. Recently we investigated a complaint from a lady who was going through a divorce, and linked with that was the financial aspect of her separation. There was a preliminary hearing listed in respect of the financial matters, and she, in her mind, felt that this meant she would have her day in court, and this was a phrase she referred to a couple of times with the solicitor. She felt she was going to be able to speak to the judge and explain her side of things and really sort of set the record straight in terms of what her ex-partner was saying about their finances. Where the poor service arose or where she was unhappy was because when she went along to the preliminary hearing, actually it wasn't that at all, and she didn't have an opportunity to speak to the judge. And the barrister that represented her at the hearing just dealt with the hearing in total. She left that hearing feeling really upset and really frustrated that she hadn't had her opportunity to have her say. In reality, with that type of a hearing, she was never going to have that opportunity. However, the communication from the firm hadn't managed her expectations in that regard and left her very upset as a result. In addition to that, we also recently had a complaint from a gentleman who was seeking to increase the contact that he had with his children, and had instructed a solicitor to represent him in respect of that. He came to us after receiving a bill that was much higher than he'd expected, in fact twice the amount that he expected to receive. In addition to this, he felt that his solicitor was never available to speak to on the phone, never answered his emails, and claimed that for 6 or 7 months no progress had been made on his case at all. So he raised his complaint with us because he was unhappy about those issues. So when investigating complaints at the Legal Ombudsman, we need to establish whether the service provided has been fair and reasonable in all the circumstances of that case. The starting point for this is to consider what we think the standard of service should ordinarily be in a matter of that nature. Once we've established what we think the service standard should be, we'll then obtain some evidence from both the complainant and also the service provider to see whether we think that standard of service has been met. For example, in the case of the lady who wanted her day in court, the correspondence that we received in that case showed that there were a number of opportunities missed by the service provider to identify the fact that she had misunderstood what the preliminary hearing would be. It was found that the firm had acted unreasonably in that situation because they could have actually managed her expectations much better than they did. Once we've established that there has been a service failing, we then need to consider what we would do to put that right. This could mean having the solicitor do some additional work free of charge. It could mean asking that the costs be reduced or some costs be refunded. But we also acknowledge that sometimes it's not possible to put something right, and actually what we need to do is just recognise that that service failing has caused some distress, some inconvenience, frustration, annoyance. We can recommend a compensation payment in respect of those kind of cases, and you can find more details about how we approach remedies of that nature on our website. As you'll have heard, many of the complaints that arise in family law matters stem from communication issues. So my biggest tip to service providers would be to really stay on top of updates and communication, which explains to your clients what the next steps of the process may be. In addition to this, communication in respect of costs is vital as well. So if you provide an estimate at the outset, make sure you stay on top of that, and if you look like you're about to reach the limit of that estimate, to provide updates and have conversations with the client to discuss what the future costs may be. Also, in respect of family law cases, it's important to remember that these are likely to be some of the most traumatic and emotional periods in people's lives. Maybe their marriage has come to an end, maybe they're trying to maintain some contact with their children. It's important to understand the emotional side of this and have empathy with the clients when dealing with family law matters. We acknowledge that this is your day-to-day work and that you will understand the processes inside out. However, it's likely that somebody coming to a solicitor or a barrister in respect of a family law matter is only going to need that service once probably in their life. So making sure that things are explained in plain English is also really important. In terms of trying to stop complaints from escalating, I think it's important to identify as soon as possible where perhaps your client seems unhappy. If they've expressed some dissatisfaction to you, then I would suggest holding a meeting as soon as possible to try and get to the bottom of that. I'd recommend staying open-minded, actively listening and actually hearing what your client is unhappy about. If you have done something wrong, if something has gone wrong, acknowledging that, apologising for it and trying to put matters right goes an awful long way and can prevent matters ever coming to the Legal Ombudsman. I hope you found this video useful. For more information about how we approach complaints at the Legal Ombudsman or more guidance about our process generally, please go to our website. Thank you for listening and goodbye.